And it's strange how you would have one piece of evidence that can tell you so much. Actually, two pieces of evidence that say so much about what may have happened here, and so many lies that surround it. Did you get a clear answer from George Anthony as to the gas cans and the duct tape? You can ask yourselves that. You can ask why he made certain statements. You recall Linda Tonelli, the woman who worked at the command center and said George used duct tape. He brought duct tape to the command center. And I'd like to re-show you this video if I can before we go any further. Gas cans and duct tape. Look at that duct tape. It's right there, almost the whole roll. And Mr. Ashton was correct when he said this is rare duct tape. This hasn't been sold since 2007 and was in very little quantities. You probably have never seen duct tape with a logo on it. It's always gray and silver. But you may recall when shortly 10 seconds after playing this video, George Anthony took the stand. And I asked him, where'd that duct tape come from? And his answer was, I don't know. There were a lot of people at the command center. Could have been anyone. He wouldn't even admit that that was his roll of duct tape. Completely denied it. He even denied the location of where this video was taken. You heard the judge enter in a stipulation into this case by both the prosecution and the defense. We all agreed it was at that location at that time manned by this person, and he got up there and said, nope, it wasn't there. It was at another place. He can't lie at all. He can't tell the truth at all, and he's confronted right there and then with this duct tape, but he wants to pass it off on somebody else. Then we had this issue with this photograph. Now, I'll bet you remember the first time I cross-examined him on this, I had some issues because it was the state's case and the photograph was not entered into evidence. The state did not use George Anthony to introduce this photograph. So when I cross-examined him, I was shut down.
Objection, Your Honor.
Sustained. Motion to strike granted. Disregard the last comment.
He was not cross-examined on this topic. But he said something very interesting. He said, sir, that photograph you're showing me, I was shown other photographs during my deposition that was not this gas can. You remember we got into the whole debate about the different, is it the round cylinder one? Is it the old one, the one you've had for 20 years? And then when it was our case, and the photograph was now in evidence, and I showed him his deposition transcripts, he went and looked at all the exhibits and then said, yeah, that's the one they showed me during my deposition. But he told you under oath that he was shown some other photograph, not this one, and played all kinds of games with this gas can. This is not a game. This is not a game at all. But yet he lied to you about this gas can. George Anthony lies when it's convenient for him. He lied to Mr. Ashton when he was taking his deposition. You may recall, give me the transcript. You may recall during Mr. Ashton's testimony, during Mr. Ashton's cross-examination, he said, you remember we sparred during the deposition? And I impeached him on this actual testimony, where Mr. Ashton said, but it is, so it's your testimony now that when they took it on August 1st, that it did not have duct tape over the vent. And George said, didn't have any duct tape over the vent. And when it came back to me, or at least the last time I saw it, now it had duct tape on it. And I didn't put it on there. But is it your testimony here? Under oath. Mr. Ashton has to remind George Anthony, he's under oath, that you have a specific recollection that when the police officers took this from your home on August 1st, 2008, that piece of duct tape was not on the can. Please answer out loud, yes or no. It was not on the can. It was not on. Lying. Here's the photograph. August 1st, 2008. The duct tape's on there. But when he's sparring with Mr. Ashton, it's not on there. Cops must have planted it. Why is he lying about that duct tape? Why? He knows. He knows that he's the only one connected to the duct tape. He knows that he's caught on video by the media, hidden behind the donation jar, that duct tape was his. And you heard Cindy Anthony testify that George was the only one that had a roll of duct tape. And we get back to June 24th. Why is he reporting this gas can missing? Why is this gas can so important to him? The only connection, the only direct link to Kaylee, to her remains, is this duct tape. Yes, you have other items, but the only one that it ultimately connects to is George. If this is their murder weapon, as they claim, they can't hide behind the duct tape. It only connects to him. Casey's in jail she's been in jail for 2 to 3 weeks before that entire roll of duct tape is photographed by the media. Look at these facts. Look at these events. The 24th, he issues a police report and reports him missing. The 15th, she's reported missing. He doesn't say a word about this alleged argument. Remember the argument over the gas cans in the trunk of the car? Here's your fucking gas cans. Well, on the 17th, a detective goes and inspects the shed. He doesn't say anything about that. Hey, by the way, I had this fight with my daughter. She wouldn't let me near the trunk of the car that smells like death. And here are the gas cans. Why don't you take them and fingerprint them? He doesn't say a word about them. It's not until near August 1st that he tells them about it, and they collect it. And they take this photograph. Then the first week of August, he's photographed by the media inadvertently, and all of the duct tape's the same. We're not talking about fantasy forensics anymore. We're talking about cold, hard evidence. Evidence that points to one person, and one person only. And he could get up here and lie all he wants and dance around the truth, but the truth is the truth. And depending on who's asking the questions, whether it's this laughing guy right here or whether it's myself.
Objection. Sustain. Approach the bench. Let the record reflect that the defendant is present along with counsel for the defendant and assistant state attorney. During this recess, I took an opportunity to go and view the video of the segment that Mr. Baez was talking and Mr. Ashton's reaction and Mr. Baez's corresponding response. Needless to say, that response on behalf of Mr. Ashton and Mr. Baez violates this court's order. Now, if both sides would like to take the time to go look at it, I will ask them to pull it up and you can look at it. And then I will proceed to do what I'm going to do. Does either the state or the defense wish to have an opportunity to view the video clip? Unfortunately, videos sometimes show it or show it the way it is. It's brief enough. I will ask Ms. Levy and I would ask in session. Ms. Levy find a place where they can go see it and bring it up. This court will be at ease until the parties get a chance to look at it. She'll come back in. I guess she's trying to figure out which room she could show it to you in. Whatever you want to say it in open court. There'll be no more sidebars, folks. Enough is enough. Whatever you want to say it in open court. Only me and me alone will know that. I have constantly told both sides from the outset when I first took over this case. I personally gave each one of you the 9th Judicial Circuit Courtroom Decorum Policy, which is enacted by administrative order and has been in place. If I can remember, I signed this order in February of 2003. I gave everybody a copy. More specifically, item 12. Counsel shall admonish all persons at counsel tables that gestures, facial expressions, audible comments, or the like as manifestations of approval or disapproval during the testimony of any witness or at any other time are absolutely prohibited. There have been this accusation throughout the trial that it has been going on back and forth. I have told you on numerous occasions I spend very little time watching the attorneys. I assume that you are all professionals, that I don't have to watch. You're all charged with the responsibility of following the law. So maybe I am misinformed when I think you will follow the law. But I'm beginning to see that orders or anything else may not mean a hill of a bean to any of you. So go look at it, and I'm going to do what I need to do.
I trust your judgment about whatever it is you saw, and I don't need to see it.
Mr. Mason, your side still wants to see it. Ms. Burdick, you want to see it?
I do, Your Honor.
Okay.
I'm sorry, I can't hear counsel.
I do want to see it. It has nothing to do with trusting in the judgment. It has to do with protecting his entity. I got what's going on.
Well, they'll let you know as soon as it's available. Okay, court will come to order. As both sides had an opportunity to view the video clip. Anything the state would like to say, followed by the defense.
Your Honor, as I viewed the video, I appear to be smiling behind my hand. That is what I saw in the video. I wasn't laughing. I wasn't nodding. I was doing what I could to make sure that my expression was not seen by the jury. If I exceeded this court's order, I apologize. But I was doing my best to make sure that nothing I said or did was seen by the jury. That's my observation of the tape.
Defense?
I have no other comments other than I would not request that Mr. Ashton be held in contempt because of his facial expressions. I think this case has been highly emotional for both sides, and all I really request is that it stop because of the serious nature of what's going on. I also apologize for getting caught up in the moment as well and making those arguments, but I think after 3 years of working with Mr. Ashton, I do not wish that upon him in any way whatsoever, and I as well have my apologies to the court.
Anything anybody else wants to say?
No, sir.
Okay. I will accept that for now, but as I told both sides, if it happens again, the remedy will be exclusion of that attorney from further participation in these proceedings. As I told you at the bench, there are at least 3 attorneys on the state side. I don't know whether Mr. George was going to participate in closing arguments, but it'll be either Ms. Burdick or Mr. George. And it'll be Mr. Mason, Ms. Sims, Ms. Medina, or whoever else y'all have over there, along with some other things that will be quite unpleasant. Enough is enough. Because of the delay, I will instruct the jury in the morning because we still have these final charges to go over. And I take responsibility for that since should have brought you back on Saturday afternoon to make you go over this charge conference. But I took y'all at y'all word that y'all would agree, and 30 minutes would be enough. Anything else? So when we finish closing arguments, then we will stay here to get these charges charged. I don't think it will take long. They're just about done. All right, let's return to jury. State recognized presence of jury. Defense? Mr. Baez, you may continue, sir.
Thank you, Your Honor. As laid out throughout the course of this trial, this duct tape only points to one person. There's some doubt here. There's some issues here. There's some things that just do not add up. There's also something that you learn towards the end of the defense case, and that is the way the Anthony family had buried their pets. It's odd. It's different. There is a pattern there that each member of the family testified to, except George, again, had a little amnesia. George, the person who actually does the burying, who does all the work, seemed to forget, but yet Cindy and Lee clearly remembered. Why, instead of rebuttal of impeaching Cindy, did we not dig up that backyard? Why did George Anthony never tell police about the way they buried their pets? 3 years go by, and there's no mention of it. There's a chance to save his daughter's life. Mr. Ashton said, why would someone use 3 pieces of duct tape? Well, you recall Mr. Murdoch testifying that one was found 6.5 feet away. You recall seeing it attached to the hair of Kaylee, which would be the top portion near the top of the bag. There's any number of scenarios of what could have happened in 6 months. There's significant movement of bones where the state clearly brought out one was found under 4 inches of muck, as they described it. That can move, but a piece of duct tape can't. I submit to you, ladies and gentlemen, that that's not reasonable. And it's also not reasonable to accept the constant lies and unique circumstances surrounding George Anthony and this duct tape. Now, I told you from the very beginning, I am in no way, nor are we in any way suggesting that George Anthony killed Kaylee. There's no evidence of that. There's no evidence of any murder in this case. And that has been our position from the very beginning. We would never point the finger at someone that doesn't support any evidence. This was an accident that snowballed out of control. Whatever happened afterwards has nothing to do with the crimes charged. They have absolutely nothing to do with that. Mr. Anthony has, on numerous occasions, had the opportunity to come up here and tell the truth about these items. But given every single opportunity, he lied. He was impeached by the prosecution during the deposition. He was impeached here. He played games with the photograph. He danced around the truth and just refused to be upfront and honest. There's one thing you can see in George Anthony, and that is that this man doesn't have an ounce of paternal instinct in him. Not an ounce. Where he got up here on numerous occasions and almost with a bit of joy testified against his very own daughter. I don't know a father in the world who wouldn't fall on the sword for his child, who wouldn't attempt to try and protect her from the jaws of death. But not George Anthony. Even Cindy Anthony tried, and you saw that. Lee Anthony, at times, was resistant. But you didn't see an ounce of that from George. George cares about George and no one else. Those were not the actions of a father. Throughout the course of this trial, as he testified, he didn't act like a father once. There were times where he actually smiled. There were times where he thought it was funny to spar with me. And there were times where he broke down and did displays of affection. But I submit to you, his displays of affection are not exactly very genuine. We had this young lady come and tell you about his displays of affection. He told you that she had a brain tumor, and he was going there to console her. There's not a tumor. There's nothing involved. She didn't have a tumor. It's 3 years later, and she's still alive. She came here and testified. She doesn't have a tumor. And he went there to her apartment at night and during the day when he was claiming to be working to console her. He's got a woman at home that needed consoling. Cindy Anthony needed consoling. He wasn't home consoling her. He was consoling her. The state tried to impeach her about, oh, well, you sold your story. Yes, she did. And we brought that out from the very beginning. But there's one thing that's certain, is that she kept their relationship private until the police came knocking on her door, until it was already out there and made public. That's when she ended up selling her story, not before. She didn't expose George Anthony and say, I had a relationship with him. And by his own admission, he knew there was a guard at that gate that saw his coming and goings. He was a high-profile person, couldn't get around, couldn't deny ever being in her apartment, because she would have been the next person on that stand. He was going to her apartment to console her for some fantasy brain tumor that didn't exist. And he came up here and he lied to you. Oh, I'm just being a nice guy. George cares about George, not about his wife, not about his daughter, not about his family, about himself. And that's what this is all about. When you read it, it's all about himself. It's a self-serving, self-preservation document. Now remember, this is January. His relationship with his mistress is now over. Cops are coming around a little too often with search warrants. And they collect that gas can again after returning it. The gas can with the duct tape, which he can't seem to tell the truth about. And they're coming around. And they're asking questions. And they're getting his fingerprints. The walls are getting closer and closer to George Anthony. So what does he do? He gets a 6-pack of beer with some blood pressure medications and claims to commit suicide. This whole thing is about, oh, I'm sorry, I'm this, I'm that, you were the best. That's all George is about, himself. He had a gun. The only reason he got a gun was to get Casey back in jail, knowing full well that there could not be any firearms in the house. This is an ex-police officer. This is someone who knows better, who the person from home confinement said, listen, these are the rules. The second they're broken, she goes back to jail. He didn't care. It's because George cares about George. If he really wanted to kill himself, he certainly could have. And it would have taken a lot more than a 6-pack of beer and some blood pressure medication. This is a self-serving document. It's more of George Anthony's lies, and it's more of George protecting George. Calling the police on these gas cans on June 24th is George protecting George and George throwing Casey under the bus. You saw the text message that he sent. He sent Miss Holloway. I need you in my life. Him and Cindy. He doesn't write Cindy and I need you in our life. Cindy's not going to her apartment at night. Cindy never went to her apartment. Cindy wasn't consoling her for her brain tumor. But he was. And before any of this, then he goes up there and denies ever saying that this was an accident that snowballed out of control. He's telling her she's dead. And still showing another face to the media and the public. And he's going around doing all kinds of media appearances. Within 48 hours of his so-called suicide, he's in front of the cameras again. If there's one thing you've learned about this family and its dysfunction, is that they don't mind putting on another face. Lies are what pumps and what lives within this family. And I told you that in the very beginning. She was raised that way. Raised to lie. Is it a surprise that she has this fantasy world? Is it a surprise that she has all of these imaginary friends? Is it a surprise that she turned out this way, knowing the lies and actually seeing them firsthand? And mind you, fortunately, they kept coming up on the stand again and again and again. So you got to see them on different days, and you got to hear them change their stories and do different things. But the fact of the matter is, they raised their hand, swore to you, I will tell the truth, the whole truth, and nothing but the truth. And they lied. So now, as their own daughter stands trial for her life, you're supposed to rely on that. You're supposed to believe in that. And these are only the lies that were uncovered. What about all of the other things that could have been investigated and never were? How is it that they didn't get his cell phone activity during that time? How is it that they can't tell us the comings and goings of that? We have the most advanced technology available to us. If we don't use it, and you don't go digging up things you don't want to find, you're not going to find them. And you're not going to have the information you need to render a just verdict. That's not justice. It's not justice. Especially when you're pouring everything you can directed at only one person and you're not looking at the entire situation. No, it shouldn't have turned out this way. Absolutely. But they should have done more. They should have looked elsewhere. They should have opened that net. They shouldn't have been walking around with blinders. They shouldn't have been trying to put square pegs in round holes. And if they had just kept an open mind, they would have seen the rest of what was going on here. They would have seen that the truth wasn't exactly the truth, and that there was more to the lies. You heard Dominic Casey and Jim Hoover. Let's get their pictures up. Take the stand. You may recall both of these were private investigators working for the Anthonys. And you heard something very interesting, and you saw a video of where they went out searching in November. You may recall Dominic Casey was the one that maybe provided us with a little comical relief throughout this trial. A strange man, to say the least. And his partner, Jim Hoover, when they went out and searched off of Suburban Drive. And not only searched, videotaped. For the very first time, they were looking for a dead Kaylee. And Mr. Casey says, well, it was a psychic that sent me out there. A psychic that was introduced to him by Cindy Anthony. And you heard Cindy Anthony get up there and deny ever sending him to the woods. And you heard George Anthony say that once I saw that video, he never went and asked Dominic Casey anything about it. He never said, hey, what were you doing out there where the remains were found? This is his private investigator who's working for him and his wife, and he never asks him. You may recall we showed you the email. It's Dominic Casey. And this is Jim Hu. You may recall this is the location off Suburban Drive in the abandoned house where they were. And I asked him, you know Orlando's 101 square miles. Out of the 101 square miles of Orlando, this is the spot that they searched. And it's circled. You remember Yuri Melich came up here and circled this item right here as to where Kaylee was found. That's where they searched. And you heard Yuri Melich say that Cindy said she had her people walk that area. Remember, he took the stand, and then Cindy got up and denied it. Well, Cindy denied it first, and then Yuri Melich impeached her. Why is she lying? And then you heard Lee Anthony impeach his mother 30 seconds after she left the stand. In fact, it angered Lee so much that he stopped taking time off from work because they were looking for a live Kaylee originally, and now all of a sudden they're looking for a dead Kaylee. And you heard him. He said, I had enough. We got into an argument over it. I confronted her. This is a young man talking about his mother. Impeaching her 30 seconds after she got off the stand. They knew where she was. Casey was in jail. They knew where she was. And they were out there searching. What do you think the odds are that they would search at the same exact spot where she would be found a month later? What are the odds in having that video? Can you even count that high? How odd is that? Is that a coincidence? Is this a coincidence too? Is this a coincidence too? Add them all together, and you've got something very suspicious going on. Very suspicious. And it has absolutely nothing to do with Casey. So, where's the truth in all of this? Where? It's not in the forensics. Where? It's not on their testimony. And these are the state's star witnesses, which one of them they had to impeach at the end of the trial. And remember, Kaylee was found with no socks or shoes. It's one fact I forgot to bring up while I was talking about the pool. That's consistent with someone who was at home. She was at home when she died. She didn't have any socks or shoes on, and they didn't recover any shoes off Suburban Drive. You remember CSI Welch? I asked her 2 questions. Did you find any socks, and did you find any shoes? And she was wearing shorts that didn't fit her anymore. Hadn't been worn in over 6 months. And she had pull-ups on. And hadn't worn them clothes in a long time. Things are just not adding up here. Things just don't make sense. it is so difficult for you to find the truth, if it is difficult for you to find the truth, then this case is not proven. There is reasonable doubt. And remember what I told you about this case in the very beginning. Reasonable doubt lives here. It's throughout the case. It's right here. It's with these individuals. It's with those individuals. It's everywhere. You can't trust this evidence. You can't. When the state rested its case, we had no burden and could have closed up shop there, but you didn't have enough information. You didn't hear from Carrie Owen from the FBI, Madeline Montgomery from the FBI, who tested the hair and found absolutely no drugs, found all the club drugs and tested for all the club drugs they could find and found none. And she said it was very sensitive, that they had a very sensitive measuring tools. The state wants you to talk about it's meaningless. Wouldn't have been meaningless if they found drugs. It's only meaningless when they don't find it. Heather Subert, the DNA analyst, who tested all of those items, the trunk, the car, her other items throughout the case. Marcus Weiss, Stephen Shaw, Maureen Bottrell, the soil analyst, who went and got every single pair of her shoes and didn't find any soil from the scene in her closet, and also those collected. Michael Sigmund, who did the air samples. Karen Lowe, Michael Rickenbach, and Lori Gottesman. 10 different people, 10 different state experts we had to call so you can get all of the evidence. So you could see that evidence either inculpates someone or it exculpates someone. And the reason they couldn't prove this case is because it wasn't true. Look at all of these. Look at all of these tests that they ran. No fingerprints on the duct tape, either at the scene or even on the gas can. No fingerprints on the duct tape at the scene. No fingerprints on the laundry bag. No DNA on the duct tape. If it was wrapped around her face, suffocated her to death, as the state claims, why isn't there DNA? Degradation? That's not enough. You heard Mr. Eichenboom testify about that. You heard Heather Subert also testify. They wouldn't have tested it if it couldn't have been on there. The FBI searched for this. It came back negative, but it had another partial profile on it. One that they contaminated and another one on the sticky side. That, remember, was the 17 marker that excludes Casey. And more importantly, excludes Kaylee. If Kaylee had decomposed all over that duct tape, there would have been cell material on there. There would have been some DNA. We solve cold cases every day, 20, 30 years later, with DNA evidence. But 6 months, we can't solve a case? We can't find DNA on some duct tape? Duct tape's it's one of the best ways of getting this type of evidence. Not only DNA, but also fingerprints. And you didn't have that. No DNA on the paper towels. No DNA in the trunk. No blood in the trunk. No sticker on the duct tape at the scene. No chloroform on the car seat. No chloroform on the steering wheel. No chloroform in the bones. Remember, they did all kinds of toxicological examinations from the saline wash, from the bone marrow, from also from her hair. Nothing to match their case. Nothing that adds to their theories, to their hopes. Remember what he called it. They only hope. Their air tests, their chloroform, no quantitative analysis. The toxicology exams, all of these drugs, negative, 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 negative. No prescription, over-the-counter, illicit drugs in the bones. No hairs exhibiting characters of decomposition out of the other hundreds of hairs that they checked. The soil examinations, all of this stuff, the shovel, everything came back negative. The greatest crime lab in our country, all of this came back negative. As I told you in the opening statements, she's dumb enough to leave her child off the side of the road just 19 feet, but she's smart enough to outwit the greatest crime lab in the country. That doesn't sound right. It doesn't make sense. It goes on and on. No tissue on the duct tape. Nothing. No maggots in the trunk outside of the very few that fell out of the bag. Everything else was in the bag. No blowflies in the trunk except that one leg. But remember, there were 75 in the bag. Well, how'd they get in there? 75 early colonizers in the bag, but not one of them made it into the trunk, or at least only a leg got in the trunk, and it was in the trash bag. And remember that paper towel had marijuana. Remember? The fatty acids that Arpad Voss tried to say was adipocere, but yet had marijuana also. That doesn't make any sense. That's nonsense. How ridiculous can you get? No discoloration inside the skull. Remember Dr. Spitz. You'd be hard-pressed. We were very fortunate to have someone as qualified as he was to come here and testify before you, to be able to tell you about this issue and how if someone dies of suffocation, you would have that. No trauma, no fractures. The list just goes on and on and on. No prior injuries. Nothing. No cause of death. It adds up to only one thing. If you look at all of the evidence here, it only adds up to one thing. And that is, she died by an accident. This was an accident that snowballed out of control. Now, again, the defense has no burden here. The defense didn't have to call these people. And the presentation of the evidence that you got from the prosecution included this person, this person, this person, this person, this person, and this person. And I would be willing to bet that most of you probably don't even remember any of them. But they failed to call this person. Do you even remember what these people talked about? But the man who finds the body is never called by the prosecution.
Your Honor, I'm going to object to counsel's violation as to number 4 in the court's pretrial order.
Sustained. Continue.
Defense called Roy Kronk to show you that there were some very suspicious circumstances surrounding his discovery. We never suggested to you in any way, shape, or form that he had anything to do with Kaylee's death. We never said he packed up her remains and took them home. But there's one thing we did say, and one thing that is uncontroverted, and that is he knew where she was and had control of that for at least 4 months. If you look at this up. This is what I showed you at the beginning of this trial, and this is what actually came out. At approximately 1 p.m., he's there with his coworkers on August 11th. He tells his friends, "Hey, I think I see a skull here." A skull. But they get distracted by the snake. Forget the snake. They forget the skull and concentrate on the snake. And he never says a word about it to his coworkers ever again. He goes home that afternoon, and calls 911 at 4:28 in the afternoon. And he tells them, "I see something round and white." He's describing a skull. They don't find anything. Nothing happens. So he calls again on 8/12. And he gives even a more comprehensive description. You have the 911 calls. So you will be able to hear them. Well, you heard them. He starts giving more of a description. And he says something very interesting. He says there was a tree there that had a fallen tree that looks like somebody had cut it. Now, if he's 30, 40 feet away, like he said, came here and testified to, how would he know so much details that someone tried to cut this tree? Then he says this: there was a white board hanging over it. There was no white board recovered. This, I suggest to you, was a marker where he may have hid her remains under the tree that took 2 people from CSI to move away. You may recall them testifying that. Well, how heavy is this tree? Is it too heavy for someone who weighs 100, 105 pounds soaking wet? Not so heavy for a man who weighs about 250, 250. He's about 6'1", 6'2". These remains were hidden. We all saw how close, the 19 feet. From here to the witness stand, maybe a little further. From the side of the road for 6 months. But there's this white board there that no one finds, no one photographs on December 11th. What happened to the white board? Who moved it? Not Casey. She's been in jail. This is in August. She's already in jail. In the short time she was out on bond, she was under house arrest, and the 10 media trucks parked outside her house. So somebody moved that whiteboard. Somebody moved that tree. At the very least, you must reject whatever was found there, the conditions of which it was found. Because as all crime scene people testified, you never get a second chance at a crime scene. You never get a second chance. If you want to get reliable information from a scene, it cannot be contaminated. It cannot be staged. If it's staged, it's useless. It's pointless to review it. Because whatever you see, you must reject. And that's what happened here. On the 13th, a police officer meets him there. Deputy Kane comes out and meets Roy Kronk to show him, so he could show him where the bag of bones are. They didn't find it. She was not found on August 13th when the police officer went out there. And all Kronk could say is, well, he wasn't very thorough. Well, it's 19 feet away from the street. And remember, there was about, as Mr. Murdoch pointed out, there was about 6.5 feet of grass. If you're this close, how can you not tell the officer, it's there, it's right there? No, the officer was rude to me. Okay, let him be rude. And just as the prosecution pointed out, why not grab the bag and go down the block and say, news media, here it is. I found her. Give me the reward. I've got a story for you. Why let the rude officer treat you that way? Why not point it out? Something is wrong here. Something very shady. And $255,000 is a motivation for someone. And he admitted it. I asked about the reward. I said I won the lottery. He said all of these things. And he also called his son in November. You heard his son say, my dad told me he found Kaylee. Brandon Sparks had no reason to come here and lie to you and testify against his father. He wanted to have a relationship with his father. They were estranged, and they were just starting to build that. He completely impeached his father's testimony. And not only did he impeach it, Mr. Kronk impeached himself. He admitted to you. On December 11th, when he happens to be urinating for the second time, 4 months later, he finds her remains. He tells the police in 2 different statements, I lifted the bag up about 4 feet off the ground, and the skull dropped out. Well, that's not consistent with what the police found. And they went back to him on the 17th, and that's where he changed his story. You heard him say it, I changed my story. 2 different statements. And what's glaring and what's missing here is on the 11th, when they ask him, so do you have anything else that's important that you want to add? He doesn't say, yes, I called you 4 times 4 months ago. He doesn't say anything. He keeps that quiet. It's not until they go back and he knows they've got them 911 calls. They've got those previous crime line tips. My story's different. I better play ball. Yeah, the skull didn't drop out. It didn't roll out of the bag. It was there. Changes his complete story. Now, I submit to you, ladies and gentlemen, how can you trust it? How can you trust anything at that scene if it's staged? Any of it. We know by Dr. Spitz has proven that it was not as they found, her skull was not as they found it. We have Kronk lying about the skull rolling out. And remember, in August, he's doing all these 911 calls and talking about a skull. The skull is outside of the bag. But yet on December 11th, it drops out of the bag. Well, who put the skull back in the bag? Somebody had to. It's in his own sworn statements. And it's not until he changes it that he admits to that. But those statements are etched in time. There's nothing that could be done. And you know now that he changed his story, and you also know now that those remains were hidden. Those remains were in a bag. This man is lying. How can you rely on any of that evidence? In your deliberation, you cannot trust this evidence. You can't trust this scene with all of this going on. You just can't. There's something not right here. And again, reasonable doubt is breathing and living in this case. And it's living right down to the very end as to when they find her. And if it weren't for the defense finding Brandon Sparks, his own son, you wouldn't have had that information. If it weren't for the fact that we called Mr. Kronk to testify, you wouldn't have had that information. You wouldn't have had any of this knowledge when making a decision to take someone's life, when making the decision to convict someone of murder, aggravated manslaughter, aggravated child abuse. You wouldn't have had any of this information. None of it. Information that you can see is critical, clearly critical. We keep getting back to that one central question, and that is how she died. And right now, as you sit here, you must certainly have more questions than answers. And the judge will instruct you on what the law is and how it must be proven. And there's no way in looking at all of these circumstances that you can say that this case was proven beyond a reasonable doubt. There's just no way. And there's various reasons why this is such. It began with part of the cover-up. It also concluded with part of the information and the investigation as to where it was carried out. To find her guilty of any single charge, any single one of them, you have to have an abiding conviction of guilt. That's what you have to have inside of you. You have to know that this case was proven. You have to know that these facts were proven. And you don't have that. And however tragic this case is, you cannot continue it. You are the ultimate deciders of what the facts are. Now, Mr. Mason is going to come up and show you the different charges and explain to you how the law will be applied in this case and how we suggest that you look at it and how the judge will instruct you on it. I thank you all, collectively and individually, for all of the attention that you have given us and the prosecution, and how you've been able to keep an open mind, despite every reason not to. I know that it has not been easy. This prosecution knows as well. And there have been times where emotions have gotten high. But you're here to fulfill an oath. You've labored tremendously over this journey. And we're going to ask you to render a verdict of not guilty on these charges because they simply were not proven. And they're simply not true. Just look at what they have and what they don't have. All the fantasy forensics in the world don't make it so. All of the lies that you've had to swim through don't get you any closer to the truth. You can't get any more serious than this. The stakes cannot be any higher. And we ask that you use the law as your guide. Thank you.
Mr. Mason. I think we better take a stretch break. Yeah. We'll take a 10-minute stretch break before Mr. Mason starts.